My talk will not at all be as visionary as Camilla's was, but I do have one comment, is that I sometimes use the same analogy to the transportation system, which is a very good one. So I will not answer the question, but I'd like you to think about what do the roads represent in this knowledge systems, and what are the vehicles in the system, and are there private vehicles and common collective vehicles, and do we need both of them, and also what are the towns or places in this system? It's an interesting exercise to think about infrastructure in that way, and that opens up, I think, the idea of infrastructure from thinking about the number of databases to thinking about a whole system of connecting things together to work together. So that's a very good analogy, I think. I think we should have a plan like that for Sweden as well. My talk will be more maybe to update you on what it looks like in Sweden currently, but also some of the things that are underway. And some of these challenges are the same challenges as you would have in Norway and in all of Scandinavia and Europe, by the way. So the first thing is, I usually illustrate the complicated landscape of registries in Sweden in this way, taking its point of departure in the health registries, which exist in a few authorities, the National Board of Health and Welfare being the biggest one. But then we have Statistics Sweden that has about 40 national registers, and surveys that are interesting to health-related research. We have 12 other central authorities with registers as well of interest to health-based research. And now we are getting about, my gosh, this looks like the wrong presentation still. We'll see what it goes like. It should say 120 healthcare quality registers, clinical registers, and we also have some 300 research and clinical biobanks in Sweden. So this landscape is very complicated, and trying to make a unified system out of it is not easy. The current legal basis based on the European Convention of Human Rights, the Data Protection Directive, which will be in effect for a couple of years on now, but which is on its way out, of course, the basic Swedish Constitution, and the implementation of the Data Protection Directive in Sweden is called the Personal Data Act, which has for the use of data, it has a purpose limitation, as I'm sure you have here as well. You must not exceed the extraction of data beyond the purpose of what you're trying to do. It has a very important exemption for historical, statistical, and scientific research purposes, which gives us the possibility to use all kinds of data in society for research. This was an issue in negotiations in Europe, I can say. And then we have a lot of separate laws on specific registers and classes of data. For instance, the patient data law, we have, I think, around 200 different register regulations that tells us what to do and how we can handle different data. We have the law on ethical vetting for research on sensitive data, and in Sweden, ethical vetting is done on a project-by-project basis, different from other Nordic countries, I think. And we also have a second vetting, according to the law of public access and secrecy. All information in Sweden is public unless it is protected by secrecy. Normally, the data we use in research is protected by so-called statistical secrecy. That's the data we get from the Statistics Sweden or from the National Board, or it's protected by patient secrecy. So the data owner has to decide whether you can get the data according to this protection as well. So we have a double vetting, very complicated system. How do you register observations or persons, and how do you participate in the registries that we are talking about here? Well, in national population registers that are created for statistical purposes, that is the data from the National Board, for instance, or from Statistics Sweden, you have mandatory participation. You cannot opt out of these registries. Everyone is registered. It covers the entire population or all the relevant events in the country, that is, all the cancers, all the care episodes in hospitals, etc. Health data include hospital data, cancer registration, prescription drug registration, medical births, causes of death, dental health, vaccinations, among other registries. Then we have clinical healthcare quality registers, and they are primarily created, of course, for follow-up of treatment. All in all, we have some 120, it should say, nationwide registries of different quality and coverage today. The local and regional registers that are in the hospitals and county councils of Sweden, they are mandatory as well. These, you cannot opt out of that system. But the national registers that we use for national follow-up, for development on a national basis, and for research, they are subject to opt-out. When you go to the hospital, you have a reminder that you can opt to not be included in the national register. Very few, I think, opt out in that way. When it comes to biobanks, well, the physical samples are supposed to be, you can destroy them according to patient request afterwards. That's the basic law, and that's what we want to implement on a national level as well. But data drawn from registers, from biobanks, I should say, are regulated like any other clinical data. So that's the other legislation that goes with that. So when we translate the physical samples into data that you were talking about, we also translate the possibility to delete those data, or the possibility, on the other hand, to use those data in research. So for research, it's an advantage to do this. Can we use the data in research? Well, in general, participation in research is optional, normally with an opt-out rule, and that's regardless of whether the data from the beginning are mandatory or not. You are supposed to be able to say that I don't want to participate in this research. For the combined research data that has biological survey and register data, that is research created biobanks with other data in them as well, like LifeGene in Sweden, EpiHealth. There you, of course, have an optional participation. You participate in this by going to the, by participating in the survey, by taking your samples. But still, ethical vetting is needed for every project that needs to use these data. Data extracted from national registers are normally pseudonymized when we use them in research. And this means, according to the new regulation, where we don't anymore use anonymized or de-identified, it's pseudonymized is a data that has a running number instead of a personal number in principle. It has a code that replaces the identity. Then But then it's still personal data, which means that it can be re-identified. Data that can never be re-identified again are not pseudonymized data. This is an advantage in the new legislation that this has been cleared, and it may be possible for us to keep data with running numbers with a code for a much longer time period than before. In practice, of course, this makes opt-out impossible once you have received your data, because you are not supposed as a researcher to re-identify the data just to meet the needs of somebody who wants to get out of the research. So in practice, all our running number data are the data that we have, and we cannot change them. So that's the way we work with this in Sweden. Some legal problems, this is from a couple of years back, led to an intense development and debate when it comes to research and creating database infrastructure. In Sweden, I look at the purpose of the Research Council was to create a common, efficient, and safe infrastructure for research. Database infrastructure, for instance, with common resources that you can use. You don't do all the work over and over again, but you have a common system. But the Swedish Data Inspection Board didn't feel this way, or they felt that the legislation says that you cannot. It stopped the collection of data for the broad purpose collection of biological and lifestyle-related data in LifeGene. The reason was that LifeGene does not perform purpose-limited research, but it's an infrastructure for such research. Hence, the data collection is illegal. A temporary solution to this, the government wrote the LifeGene law, which says, well, you can collect data for this type of research that looks at the combination of lifestyle and biologically inherited aspects and health. This is a temporary solution. The law will stop at the end of 2017. The data inspection stopped the data services of the Data Archive Library, Swedish National Data Service, which is a place where you can reuse data. Reason: the Swedish National Data Service does not perform purpose-limited research again, but is an infrastructure providing data for such research. Hence, the handling of personal data is illegal, also according to the Swedish law. It prohibited the construction of a search system in BBMRI for researchers, which was intended to find biological samples, that is, a national biobank register. Reason: the search system is not purpose-limited research, but an infrastructure. Hence, personal data cannot be handled legally in this system. Solution would be to create a national biobank register based on a law that says that it can exist. So this is the same problem coming over and over again in our legislation. We had an official inquiry which was called Unique Knowledge Through Register-Based Research, trying to address these problems. That came in the summer of 2014. It has now been awaiting the European legislation, so nothing has been done yet, but this is what they suggested. Change the law on ethical vetting, chairperson decisions for simpler cases. Regional boards should be mandated to leave advisory statements for the type of thing that Camilla mentioned, that is those cases that apparently are not research but are something else. And they have been in a limbo even in Sweden. And sometimes they couldn't even use data because they are not research, they are not statistics, they are not follow-up. So we have to stop that. Well, the third suggestion here is to make the law on ethical vetting applicable to research databases also, and not just research. Change the law on official statistics so that key codes should be kept at least 20 years, longer after application. Introduce a new secrecy concept in the law of public access, which would be called research secrecy. Absolute secrecy for at least 70 years, which would then be parallel to statistical secrecy, and then would make the data in research-oriented databases as protected as they are elsewhere. A new general law on research databases, saying that research is on the level of other important societal goals that should make it be a basis for collecting broader types of registries. A national biobank register in the National Board of Health and Welfare. So this was the content of that. But in the meantime, what happened in Europe, and here we're getting into what happened to you as well, I think. In January 2012, the Commission proposed a new law on data protection. This is after many years, really in 1998. It all started the process of getting a new legislation underway. Intense debate followed this proposal. Close to 4,000 submitted opinions for and against, more restrictions, less restrictions, etc. Researchers feared that much of their activities would actually be prohibited, such as mandatory health data registers, for instance, and register-based research in general. I will not go into the details as to why we thought so, but the final agreement on the new General Data Protection Regulation was reached in the end of April this year, and it will be in force as from May in 2018. Replaces the national legislation for the EU and associated countries. But we need a lot of additional member state regulation, and we need to adapt our rules according to the GDPR. The purpose of the GDPR was to strengthen individual rights, adapt legislation to a modern information society, reduce European heterogeneity, achieve the same protection for individuals when you cross borders in Europe, and facilitate then cross-border movement of data, which had been difficult up until then. Outcome, in general, increased individual rights to decide over your own data, to get more information, to be deleted from databases, to object to personal data handling, etc. But many aspects of research would then be subject to exemptions. This is also true for archiving purposes and for statistical purposes. Mandatory registers, very important, containing personal identification numbers are still legal according to this new legislation. Some exemptions are already written in the GDPR, but many of them need a basis in national law, especially research without informed consent that is based on what is called the public interest in Article 6 of this. I participate in this research data inquiry of Sweden, which is one of several inquiries, Swedish inquiries on the GDPR. The basic inquiry by the legal Justitiedepartementet is called the Data Protection Inquiry. Another very important inquiry on the consequences for the Ministry of Social Affairs deals with health data registers, social insurance legislation, the patient data law, etc. They have a lot of things to do in this ministry. The research data inquiry we should adapt legislation to the GDPR proposal in June of next year, and also propose long-term regulation of research databases in December. The question is, which national regulation for research purposes is possible and needed beyond the GDPR? Should we have a research data law? Appropriate safeguards must be in place. Propose those. Should we extend ethical vetting to all personal data handling? It is already extended to genetic data and some other areas in the GDPR. The Swedish question is, should we extend it to meet this requirement of appropriate safeguard to all personal data? Do we need separate legislation for special categories? That's what we have called up until now sensitive data and data on criminal behavior. We must have rules to be able to make exceptions for research on these individual rights that I was talking about earlier. The right to get information, correction, limitation of handling of data, objection to handling. The procedures in ethical vetting, follow up on the 2014 Register Research Inquiry that I was talking about before, and adopt some other register law. The Life Gene Law, we have a law on the Forensic Psychiatry Register that we need to look at. We need to figure out new rules for or clarify protection of deceased persons in forensic research. And long-term legislation on research databases. There we have this, I have copied a piece of the GDPR preambles where it says that it is often not possible to fully identify the purpose of personal data processing. So therefore you should be able to get consent for broader purposes than before. And this is a promising development, I would say, if we want to create an infrastructure that works for us. Here something is missing. This should describe the clinical registers. The future for clinical registers is that we today have some 120 national registers. There has been a focus on developing them that ends by the end of this year. A project group has now been appointed to propose a stable and long-term solution to be presented to the government in the spring. Both clinical and research interests are represented in this, so we will get some type of permanent funding of our clinical registers in the future. There we have it. Finally, how much time do I have left?
Oh, you have at least 10 minutes.
Okay. The Research Council is building an information infrastructure, and I think the coordination of all those sources of data really is a big challenge, and what we need to do first, and what will accomplish a lot, is when we can get an information infrastructure that works for researchers. There are two components in this. One is a portal called Registerforskning.se, and another one is something called the Register Utilizer tool. The agency is commissioned to improve conditions and prerequisites for register-based research. This is done by setting up a registered data council with directors from big register data holders, from the Data Inspection Board, and senior researchers. This is done by developing information, advice, and education, and this is done by improving accessibility by coordinating the data sources. Registerforskning.se is a national portal for register-based research. Unfortunately, I will say it's only in Swedish so far, Swedish authorities need to have Swedish language as their first priority. I guess the same goes for Norway. I don't know, but we have it only in Swedish. It has information and support through the entire research process, information on how to order data, and information on legislation, listing of registers, clinical registers, administrative registers, and biobanks. This is what it looks like when you go in and look at it. Those of you who read Swedish can take a look at it. I think Denmark has the same thing now, called Registerforskning.se, under development. The other part is a register utilizer tool, which is a tool for exploring the variable content in Swedish registers and biobank. This is a prototype that is being tested until the end of 2016. And it contains only metadata, no information on values in the registers, no personal data. Contains today metadata on a couple of registers from Statistics Sweden, and a couple of clinical healthcare quality registers are there or on their way in. Diabetes, rheuma, stroke. Metadata from biobanks, KI Biobank, Uppsala Biobank are on their way in. We had very positive feedback on this from active researchers and data owners, but of course one part of it is that you need to have everything in here in order for me to be able to use this to create my applications. So this is the big challenge. How do we implement this further? It takes a lot of resources to do this, and there is a decision in November taken by the government on the future support of this structure. This is what the system essentially looks like. You can search for a variable through these parameters, and then you will get in to see a register structure, which gives you a visual way of looking at what the register looks like, how it's built. You can get into single variables and get out information on what does this variable mean and how is the variable related to other variables in the system. You have some detailed information on variables. And you have a collection protocol which also shows you which populations are available. You cannot do the search for how many observations will I find with these restrictions, unfortunately. But you have a basic restriction on what is the basic population that I collected these from. And the definition, reference period, description, etc. Finally, researcher collaboration I haven't talked so much about. But we have several initiatives as well. For instance, we have an initiative underway which is called cohorts.se, which is an effort to create an organizational and technical infrastructure to facilitate access and collaboration between clinical registries, cohort studies also within other areas like social science are there as well. Currently, some 35 epidemiological and other cohort studies are members of this system, which is being built now and which is seeking infrastructure support from the Research Council in the spring. We also have this idea that if you cannot share data easily, you can at least share codes with each other. This is more or less an idea. That is to exchange statistical code, for instance, through a GitHub system where you can show other researchers what you did in terms of data management and to some extent also simple, maybe descriptive statistical analysis in order to collaborate across project group borders in this sense. Now this needs to to sit in some infrastructure which can handle a research user community, which makes it slightly different for an authority to host it. But for now, it sits with the Swedish National Data Service. And I encourage you to come up with good ideas on how to do this in the future as well. So thank you.
Thank you very much. We have time for one question for Magnus Stenbeck, if there is somebody who is really ready to ask a question. There is the time.
To me, the solution of, I have problems with the word, pseudonymized
Pseudonymized, yeah.
data sets.
Yeah.
I'll just say pseudonymized, but that's something else, I think. I think that's not an optimal solution, because then you are at some endpoint. You cannot add anything else to that. You have to start all over again if you want to increase your data set. But still, you have chosen that as, and not you maybe, but the authorities have chosen that as a general procedure.
We had a scare towards the end of the decision of the GDPR that pseudonymization would be a mandatory solution. And it was driven by Germany and some other countries to make it obligatory to pseudonymize even data in the basic registries. But now it says in that paragraph, safeguards such as pseudonymization, if possible and if the purpose can be fulfilled in this manner, which is a qualification which makes it, you're absolutely right. In the basic registries, we need personal IDs. For limited projects, and also if you can keep the key for a long time period, it might be sufficient in some cases with pseudonymization. But I agree completely with you that the basic thing is to have personal IDs. The thing is that the legislation says that you have to have some kind of safeguard in order for this to be legal. Then we have to find something else, technical solution, something else, some other legislation, what have you, to protect the data instead of the from Germany preferred solution of pseudonymization. But I do agree it should be used with caution.
Well, thank you very much.
Thank you.
For an interesting presentation. And
Thank you.
Thank you.